Hello again, folks, and we're back with understanding General Sessions Court, and we need to find out or need to understand what can happen in General Sessions Court. Well, three things can happen in General Sessions Court. We can have a preliminary hearing, we can have a trial, we can have a plea. Okay, let's talk about those things. Number one, a preliminary hearing. We've talked a little bit about this in other chapters, but a preliminary hearing is a time when the state of Tennessee puts on some of their evidence, not all their evidence. They don't have to show all the cards in their hand right now. They have to show enough evidence to be probable cause. You say, what's probable cause? It's a big legal term, but basically it means if it walks like a duck and talks like a duck, it's probably a duck. Okay? Is it likely that something happened? Is it likely that this is the individual? That's all it takes. It's not much, but it's something. And it's over time that the state has to put on some of their proof, some of their witnesses, and your attorney, me for example, can cross-examine, can ask questions, and get the witnesses locked down on what their testimony is going to be. That's good because you don't want their testimony to change later on. In General Sessions, I have a preliminary hearing and a person says, I never saw a gun. And then we get into trial and they say, oh, he was holding a gun on me. It was silver. It was, a 6-shot revolver and Smith & Wesson 22 caliber. What about that gun you didn't see earlier? I've had people, between preliminary hearing and trial decide that they saw guns that they didn't see before. They have forgotten about guns they thought they testified to earlier. All kinds of interesting things happen. You can have a preliminary hearing. Number two, you can have a trial. Now, I want a trial by a jury. Now, you don't get trial by jury in General Sessions Court. In General Sessions, you have a trial by the judge only. It's called a bench trial. If you hear people talk about a bench trial, it's not a trial on a place that you sit down at the park and feed the pigeons. A bench trial is a trial only with the judge, no jury. Now, sometimes that's a good thing. Listen to your lawyer. Sometimes I've had bench trials. Now, why would I want to have a bench trial? Well, there may be a technical legal reason that I can get the case dismissed, and I've done that before. I had a bench trial one time where as soon as the state put on their first witness, I made a motion and said, Judge, we need to dismiss this case because they've charged him under the wrong law. And they did. When the judge dismissed it, jeopardy had already attached. And then you think, no, jeopardy is a TV show. No, jeopardy is a legal term that means I can't be tried twice. Okay? You can't be tried, for example, you go to General Sessions Court and I want to have a bench trial. I can't be tried for, let's say, simple possession of marijuana, and the state's case is, the judge says, I don't find him guilty, find him not guilty. The state of Tennessee can't say, well, tomorrow we want to try him again, see if we can do a better job next time. Or, Judge, you said not guilty, so we're going to go ahead and indict him for the same thing, same case, same day, same channel. And we'll roll the dice again. No. One shot. Now, there are very particular reasons. There are a lot of circumstances and facts that can go into that. Listen to your lawyer. Get your lawyer. Get my office. We'll help you out. Do everything I can for you. But in General Sessions Court, you can have a preliminary hearing. Now, you may say, Jeff, I had a preliminary hearing, but I didn't get to testify. No, I wouldn't want you to testify. I mean, in 18 years of doing this, there's probably one or two times that I've had a client testify in a preliminary hearing. Never. There is no advantage to my client testifying in a preliminary hearing. I mean, it's just almost no advantage at all, so I'm not doing it. Jeff, I had a preliminary hearing, but I didn't get to put on proof. I don't have any obligation to put on proof in a preliminary hearing. The only thing that's going to happen is the state's going to decide about probable cause. Now, if I were going to have a General Sessions trial, if I were going to have a bench trial, First, the state of Tennessee has got to agree to it. If they don't agree, if they said, we don't want to have a bench trial, then I can't force them to have one. But let's say they say, okay, we'll agree to have a bench trial. Yeah, I might want my client to testify. I probably will want to put on proof. I may or may not. Let me make that decision. Okay, a bench trial, a preliminary hearing, a plea. That's the third thing that can happen in General Sessions Court. What can I plead? I can plead guilty, not guilty, best interest plea, nolo contendere. What in the world? Guilty. That means the police say that I was smoking a joint down at the corner of Dickerson Road and Old Hickory Boulevard, and I say, yep, sure was. Lit it up, it was good, had a great time, I'm guilty. I can say, in my best interest, which means the police might have said you were smoking a joint and you had 2 kilos of cocaine sitting there beside you. And I could say, well, I don't think I was smoking a joint, but I sure don't want to be charged with 2 kilos of cocaine, so yeah, I'll go ahead and plead guilty to simple possession of marijuana. That's in my best interest. I might say, well, nolo contendere, no contest. That means ain't fighting it, ain't running away from it, I ain't saying I'm not guilty, I ain't saying I'm guilty, I just ain't saying nothing. No thank you, I'm saying nothing. The judge will find me guilty. Okay, so wrap up. What do we have in General Sessions Court? Preliminary hearing, General Sessions trial, plea. Now you know what to expect in General Sessions Court.